I'm Dr. Michael Hart, and this is a presentation for the Constitution Day of 2021 for College of Southern Nevada. Before I go on with my content, and I remain solely responsible for the content, warts and all, I would like to acknowledge a few people. Dr. William Eric Davis, Social Science Department Chair, and Dr. Robert Tamara, Events Committee Chair. And these two gentlemen have been very hardworking for many, many years now in facilitating Constitution Day at College of Southern Nevada. And also, I would like to know Dr. Kenneth Fernandez, our lead faculty in political science, who is an expected contributor this year and also has a history of helping us out with technical details, and Dr. Francis Carlton, political science faculty, who is also one of the expected presenters this year. Now, I take a case study approach in this Constitution Day presentation. In the case I will review is Torres versus Madrid. It's a Fourth Amendment case. We're coming up on the 230th anniversary of the Bill of Rights. The Bill of Rights was written in 1789, but was officially ratified on December 15th, 1791, added to the Constitution when the requisite number of states ratified. So it's been 230 years, and the Fourth Amendment is one of the 10 amendments of the Bill of Rights. The Fourth Amendment is one of the more complex amendments. Its interpretive landscape is very involved. Perhaps only the First Amendment surpasses just the vastness and the complexity of interpretation, and maybe the Fifth Amendment rivals it in terms of the vastness and complexity. The Fourth Amendment has two clauses, the Search and Seizures Clause and the Warrant Clause. And for the case in hand, we only need to consider the Searches and Seizures Clause, and particularly we will be concerned with the meaning of seizures. So the Searches and Seizures Clause reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated." So clearly, reasonable seizures are allowed. Unreasonable seizures are not. And the question here in this case is, has the seizure occurred at all? Has the seizure within the meaning of the Fourth Amendment occurred? And the specific questions can be put this way. In this case, as in most cases, questions can be phrased in more than one way. So one way to phrase the questions involved in Torres versus Madrid would be, if a person has been shot by law enforcement with the intent to apprehend, has the person been seized? And the second question is the seizure continuous? In other words, if a law enforcement officer shoots you with the intent to stop you, has that officer seized you? And if so, is the seizure permanent, or can seizure be terminated if you flee successfully from the officer? This is what's at stake in Torres versus Madrid. The court, by a 5-4 decision, held that, in fact, yes, shooting a person with the intent to stop them is a seizure, and no, the seizure is not continuous. It's a singular act, not a continuous fact. So in fact, if you flee from law enforcement officer following the application of force, even application of force at a distance, such as in this case where Roxanne Torres was shot multiple times and 2 of the bullets hit her in the left shoulder, temporarily paralyzing her left arm. So what happens is you are seized, but you are seized only for that moment. If you flee, then seizure is interrupted. So why is this important? Well, it's important because it involves power of law enforcement versus the power of criminal defendants. And the case pertains, generally speaking, to the extent of power possessed by law enforcement in society. So if seizure has in fact occurred once you've been shot with the intent to stop you, then if that application of force is unreasonable, if the seizure is unreasonable, then law enforcement is potentially open to being sued for civil rights violations. And under 42 United States Code, paragraph 1983, a law enforcement officer can be personally liable if, in fact, the court finds that the force used was unreasonable given the circumstances of the case. So the facts were quite straightforward. Two police officers approached Roxanne Torres's car. She mistook them for carjackers, because she was experiencing methamphetamine withdrawal. And so it was kind of already getting dark, and police officers were wearing dark tactical vests. They also wore badges, but Torres said that she didn't recognize them as police officers. She just thought they were carjackers. So she starts driving away, and they shoot at her, and 13 shots, and as I said, two bullets found their marks. Roxanne Torres later pled no contest to 3 charges: aggravated fleeing from law enforcement officer, assault on a police officer, and unlawfully taking a motor vehicle. Because what happened was, once she made her escape, after some distance, she got out of her car, approached a bystander, told that bystander to report an attempted carjacking. So she is playing the victim, right? She gets away from the police and then gets out of her car, tells a random person, "I've been a victim of an attempted carjacking, contact law enforcement." And then she steals a nearby car, a nearby Kia, which was idling. And so she gets into that car and she drives approximately 75 miles to a nearby town, Grants, New Mexico, where she receives first aid, and then is airlifted back to Albuquerque, New Mexico, where the facts of the case took place. And there she gets more thorough treatment at the hospital. And after receiving that treatment, she is arrested finally by law enforcement. So what is the bottom line in terms of seizures? Law enforcement's position in this case was that seizure occurs only when there is acquisition of physical control. So law enforcement argued there has to be the singular standard, acquisition of physical control, which itself can be effected in 2 ways. First, show of authority and yielding to that authority. So if the police approaches you and says, "Police, stop," and let's say you raise your hands, that's yielding to authority that has been shown. That's a seizure. Another way that seizure can occur is if you're physically being controlled. Let's say you're handcuffed, and you cannot get away. That's a seizure. Law enforcement denies the idea that shooting somebody is a seizure. That's not a seizure within the meaning of the Fourth Amendment, according to them. But the Supreme Court rejected this argument. It's clear why law enforcement would not want to consider shooting somebody a seizure, because they want to avoid potential liability. But as it happened by a 5-3 decision, the court rejected their position. So she was indeed seized. Roxanne Torres was indeed seized. And the seizure was temporary because once she got away in her vehicle, she was no longer seized within the meaning of the Fourth Amendment. So what about ideology and the Fourth Amendment jurisprudence? Torres is one of the landmark cases of the 21st century. I think it's already safe to say that, even though the case has only recently been decided on March 25th, 2021. And what we see here in this case is lack, really, of ideological unity. We saw that the 5 justices that ruled in favor of Roxanne Torres included 2 conservatives, Chief Justice John Roberts and also Justice Brett Kavanaugh, as well as 3 liberals, Justices Breyer, Sotomayor, and Kagan. Now, on the dissent side, you had 3 conservatives, and they were Thomas, Alito, and Gorsuch. And Justice Gorsuch wrote a passionate dissenting opinion in this case. So clearly you see the break in ranks among conservatives here, with 2 out of 5 actually going the other way, siding with the liberal position and with the interests of the defendant against the interests of law enforcement, against the position of law enforcement in this case. And one of the suggestions for future research would be to do systematic analysis of this ideological breakdown when it comes to Fourth Amendment cases. What I can already point to at this time is that during the first 21 years of the century, we have already had a number of landmark Fourth Amendment cases where we see that when it comes to criminal procedure, there is no ideological coherence. Cases that I would mention in this regard would be Kylo versus United States versus Jones, Riley versus California, and Carpenter versus United States. Along with Torres versus Madrid, these cases represent losses for law enforcement and victory for criminal defendants. And all of these cases show unexpected or unusual ideological breakdown. So in Kylo versus United States, which was a 5-4 decision pertaining to thermal imaging without a warrant, in that decision, you had a majority which was led by conservative Justice Scalia. And he obviously ruled in favor of Danny Kylo. And on the dissenting side, you had a liberal Justice Stevens, writing the opinion for the dissent. So you didn't have a neat ideological liberal versus conservative breakdown as you might expect, with conservatives taking the position of law enforcement and liberals taking the position of criminal defendants. Not at all. And then in the United States versus Jones and Riley versus California, you had stunning unanimous decisions where liberals and conservatives in both of those cases unanimously sided with the rights of the defendant and against the position of law enforcement. So the United States versus Jones was warrantless search that involved GPS, placing GPS on a person's car without their knowledge, without their consent. And the court said that's a violation of the Fourth Amendment. That's an unreasonable search. Riley versus California, also unanimously, the court said that you cannot search the contents of a person's cell phone without a warrant, even if the search is incident to an arrest. The outer shell of the phone can be searched, but you cannot search the contents without the warrant. And in Carpenter versus United States, you had a 5-4 decision in which the court said law enforcement needs to get a warrant to get cell phone tower data from cellular wireless carriers. They cannot get third-party data without having a valid warrant first. And in that case, too, there was not an neat ideological breakdown of liberals versus conservatives. So it's good to remember when we think of all of these cases that there is now in the 21st century a long line of jurisprudence, which tells us that when it comes to law enforcement, the traditional ideological divide is not very telling with regard to predicting how a case will turn out and which justice will rule in which way. So as politically we discussed the role of police in society, the extent to which law enforcement should have more powers or fewer powers, we should remember that ideologically it's not all that simple. It's not liberals versus conservatives, Democrats versus Republicans, at least not as much as we might assume. And lastly, I want to point to the role of Justice Amy Coney Barrett. Her role in criminal procedure cases is still being defined. When the Torres case was being discussed by the court, she had not yet been confirmed. So she did not participate in this decision, which is why that was a 5-3 decision. The ninth justice did not take place. Amy Coney Barrett did not take part in discussing this case. So as we move forward, and as the current president or the next president makes another appointment soon, it will be very interesting to see how criminal procedure cases turn out. Even as I record this, Justice Breyer, who is 83, has made some noises with regard to being open to retirement and being replaced by the current Democratic president in office. Breyer is still very vigorous for his age, and you can actually hear that and sense and experience that as you listen to oral arguments and Breyer's exchange with the lawyers in this case. The oral arguments in this case last for about 1 hour and 17 minutes, and also present an interesting picture of the positions on both sides. So this is my presentation. So it was a privilege to make it, and I hope that you have learned something instructive and significant from it. Thank you.